Good morning, this is your Kelso Report for Wednesday, July 11th, and I'm your host, Clark Kelso. We begin with the Ninth Circuit with an interesting product liability case. In Rosa versus Taser International, the Ninth Circuit affirmed summary judgment in favor of the manufacturer of tasers in a wrongful death action against the manufacturer arising out of the death of someone who was shot multiple times by tasers in the course of being taken into custody. He died of a cardiac arrest brought on by metabolic acidosis. The death occurred back in 2004, and the issue before the court was whether the scientific evidence at the time established that tasers posed a risk of triggering metabolic acidosis, leading to cardiac arrest. Now, under California law, a manufacturer has a duty to warn of a particular risk if it is, quote, known or knowable in light of the generally recognized and prevailing best scientific and medical knowledge available at the time of manufacture and distribution, close quote. The plaintiffs introduced 4 studies published before 2004, but none of the studies actually concluded the use of tasers causes metabolic acidosis. So the Ninth Circuit concluded that it was speculative whether such a risk had been established as of 2004, and the court affirmed summary judgment against the plaintiff. And in case you are wondering, beginning in 2009, the manufacturer had added language to its warnings specifically referencing the risk of metabolic acidosis contributing to cardiac arrest as a possible risk of the product. Of course, even with that risk, let's face it, a taser is a lot less risky than a gun with a bullet. Our next case, California Court of Appeal, involves driver's licenses. Section 13352A3 of the Vehicle Code provides that a driver who has been convicted of DUI on more than one prior occasion may request from DMV a restricted driver's license during the term of a current license suspension resulting from a current DUI conviction. The petitioner in LaChance v. Valverde pled guilty to a DUI, and the DMV suspended her driver's license for 6 months and concurrently imposed a 1-year administrative per se suspension. This is all routine at this point. She then requested a restricted license, but the DMV rejected her request because this was her first DUI conviction, and the statute permitting issuance of a restricted driver's license that she cited applied only to persons who had previously been convicted of a DUI. Now, although the result here seems a little counterintuitive, the 4th District held that DMV had properly denied the restricted license because the express terms of the statute she cited do not give DMV any discretion to issue the restricted license in these circumstances. As the 4th District noted, a restricted license might also have been available to a DUI first-timer under an entirely different statute, Section 13352.4. But the petitioner failed to apply under that statute and raised the issue for the first time only on appeal, an argument the appellate court considered to have been waived. You got to get your statutory arguments in line before you can seek your restricted license. Next case involving labor law, the plaintiff in De Leon v. Verizon was a retail sales representative for Verizon Wireless. He sued Verizon, claiming a violation of Section 223 of the Labor Code, which prohibits the secret underpayment of wages. That is, in the language of the statute, quote, secretly paying a lower wage while purporting to pay the wage designated by statute or by contract, close quote. Well, the plaintiff's compensation plan included commission payments, which Verizon Wireless could recover or charge back against future commissions if certain conditions were not met. The 2nd District held this was not a secret underpayment, because the commission payments were in effect actually advances not wages. And the chargeback provision did not violate the Labor Code because Verizon Wireless may legally advance commission payments to its retail sales agents before completion of all conditions for payment, and then charge back any excess advances over commissions earned against future advances should the conditions not be satisfied. The difference between an advance and a wage. Next, we have a case involving reunification services, juvenile law, and a decision that I think exalts statutory literalism over substance. The First District held in Melissa R. versus Superior Court that the Superior Court had erred in denying family unification services because of its finding that the affected parent had previously failed to reunify with another sibling in a Wisconsin proceeding. Section 361.5b10 of the Welfare and Institutions Code does indeed authorize denial of reunification services if there has been a prior failed attempt at reunification. But the statutory language refers to failing to reunify and being removed from the parent, quote, pursuant to Section 361, close quote. Well, focusing on the literal meaning of that phrase instead of its substantive meaning, the First District held that a failure to reunify and a removal from another state does not satisfy the statutory requirement that the removal be pursuant to Section 361. Seems to me the First District's literalism has missed the point of the statute. Well, that's it for today's cases. Have a great day in the law.